While the risks of economic, political, and social costs connected to the use of AI cannot be considered inherent to the nature of these technologies, they are, however, closely linked to the specific ways in which the latter are used and to the tools that are actually developed for this purpose. Compared with most technologies of the past, the most advanced AI systems may have substantially greater capabilities and thus present substantially larger privacy risks when compared with previous technological innovations. For what refers to the selection and hiring practices, the use of relevant data in algorithmic hiring systems aims to allow not only a rapid assessment of the profiles of potential employees, but a better match of the available skills with the specific needs identified by companies, improving the efficiency of the selection processes. However, candidates are often unaware of how their data is being collected, processed, and used by AI tools, particularly when information is scraped from public to online sources. This lack of transparency undermines informed consent and a candidate's rights to challenge automated decisions. Even if the final decision is carried out by a human actor, profiling and rating employees is already commonplace in the pre-employment and screening phases to analyze and compare curriculums in order to select the most suitable candidates, based on the parameters used by the algorithm. AI algorithms can analyze seemingly innocuous data, like names, social media posts, or geolocation, to infer spatial category data, such as ethnic origin, religious beliefs, health status of the future or prospective worker. This information is often irrelevant to the job qualification, and its processing without a lawful basis can violate data protection laws like the GDPR and lead to discrimination claims. Furthermore, it has already been shown that if AI systems are trained on historical data that reflects existing biases, they can perpetuate and amplify this pattern of discrimination, leading to unfair treatment of certain groups of candidates. In terms of the organization of employment relationships, it is possible to identify a series of systems dedicated to the algorithm management of labor relations, which include both workforce planning and coordination and control of employee activities. Artificial intelligence can be an effective work tool, supporting health and safety or assisting workers in performing their task, thereby increasing their productivity. However, the consequences of these developments is that in many areas, the processing of personal data has become practically omnipresent, increasing the possibilities of abuse and discrimination and significantly influencing working conditions. Workers' performance and behavior is continuously monitored in real time and in extreme detail in order to predict errors or highlight inefficiencies, leading to an extension of the employer's power of control over the employees, which is unacceptable from the perspective of labor law. Systematic profiling of employees can also lead to the use of automated systems in order to make support relevant employment-related decisions, such as career progression, access to training and to employment opportunities, including the transfer of employees and even the selection of redundant staff. Lastly, employers appear to be able to implement increasingly persuasive control through a series of technologies to monitor and control employee behavior in the workplace, evaluate their performance in real time, but also follow their activities if they carry out their work remotely or in a supposedly autonomous way. The use of AI has the potential to become a central element of collective negotiation and bargaining, to specifically define the parameters of its use, but also in the sense of anticipating future skill needs. It appears also necessary to allow those affected by the outcome of an AI decision to receive the necessary clarifications regarding the data and factors taken into account in the decision-making processes and the specific methods and processes through which a certain result was reached. After the employment relationships has ended, there are a series of questions concerning the need to preserve data in order to feed the AI system relevant information. Some AI tools collect far more personal information than necessary for recruitment and employment purposes, which violates data minimization principles in various privacy regulations. Furthermore, this information is retained for an indefinite period of time and may very well be considered as inextricably linked to decision-making processes once it is included in the data utilized by the AI systems, a circumstance that may conflict with the right to erasure, especially when the employment relationship has ended, either by resignation or dismissal. For centralizing large amounts of sensitive employee data in AI systems creates also new vulnerabilities for data breaches, requiring robust cybersecurity measures. With respect to data retention frameworks, the Court of Justice of the European Union emphasized that the more serious the interference in fundamental rights of a data retention measure is, the more important to the pursued aims must be, and set out a series of requirements in order to ensure that the data retention does not allow precise conclusions to be drawn about the private life of the persons in question. IP addresses and civil identity data are to be kept separated by means of secure and reliable computer systems, and regular review of the system and its effective functioning must be carried out by an independent third-party authority. Given the rapid pace and unpredictable nature of AI development, a regulatory context that favors the development and consolidation of the use of these technologies in the absence of explicitly and legally defined guidelines and principles can lead to results and trends that are difficult, if not impossible, to reverse, even in the face of an incomplete maturation of the technology in question.